Topic 8 on discovery. So a reminder of where we are. The plaintiff has commenced proceedings. The defendant has acknowledged service. And both parties have now filed their pleadings. So we have gone with close of pleadings. The next step in the action is discovery. What it means is it refers to the process in which both parties have to disclose to the other side the existence of relevant documents. So long gone are the days where the barrister can, during the questioning of a witness, suddenly produce some damning evidence, show to the witness, this shows that you're lying, and you catches everyone by surprise. Okay? This does not happen anymore because now modern litigation, in civil litigation, there's no ambushing the other party. Okay, both sides has to adopt a cards on a table approach. So it refers to us playing poker, but your cards are on the table. So both sides, we clearly know what the other side has in terms of evidence and documents. It avoids the parties from being taken by surprise. So therefore, each party can better evaluate their strength and witnesses of the case before trial. Why is that? Because modern litigation, we want to encourage settlement. We don't want people to, under some kind of mistake, thinking that they have a strong case, not knowing what the other side has. Okay, so hopefully, if one party has a weak case, this party would have been advised to settle and not to spend all that money on legal costs. We have automatic discovery. So Order 24 Rule 2 says 14 days after close of pleading. So we know what that is. 14 days after the last service of the reply, it is close of pleadings. And 14 days afterwards, there is a automatic discovery where both parties must exchange something called a list of documents. Exception. So this automatic discovery does not apply to these actions. It does not mean that there's no discovery. It means the court may still order discovery there, but only in a writ action there is automatic discovery. Parties can agree within themselves to dispense with or limit discovery. So they can agree to let's just restrict the scope of documents to certain years or certain subject matters or certain issues. A party, so even though there's no agreement, a party can apply for the court to limit discovery. So unilateral apply to the court within 14 days of the time limit to specific issues, or exchanging copies without the need to prepare a list of documents. Legal costs can often be huge. So therefore, it might be desirable for both sides to limit the scope of discovery. And of course, the court takes into account the underlying objectives. In particular, we are talking about proportionality. Okay, so what must the lawyer do? Two main things are on the lawyer's part. That is, you must explain the duty to the client. Now, most often, the client will not understand this. And of course, they have an interest to hide documents that are not in there, that does not help their case. So lawyers must explain the duty, the importance of preserving documents which may be discoverable, and important one is the continuing discovery obligation. So even though today or next week we look at all the documents, we decide which to disclose, but there might be in the future I discover more relevant documents. So your duty then is to provide a supplementary list of documents. So it does not stop as soon as you file your first list of documents. Lawyer also has to conduct discovery properly, okay, with regard to, so you must remind your client about disclosure, and another important part is you study carefully the other party's discovery. So with experience, then you can tell if the other side are hiding things, and that may prompt you to make some interlocutory applications for specific discovery. What must be disclosed? There are three requirements. Okay, so documents that are relevant, and they must be in the possession, custody of or power of the party, or used to be. So presently in possession, custody or power, or in the past. So anything satisfying these three requirements must be disclosed. Document does not refer only to paper documents, but also any other media. So it could be tape, video, negatives, and computer. What is meant by relevant? This test is very wide. We take this from the Peruvian guano case. You can see how wide it is. So any evidence which may, not must, may, either directly or indirectly, enable the party either to advance his own case or to damage the case of his adversary, if it is a document which may fairly lead to a train of inquiry. Okay, so either it helps you or help the other side. They are both relevant. Relevance is judged by the issues pleaded. So therefore, that's why pleadings are very important. They define what are the facts in issue. And based on that, we conduct discovery. Based on that, the court determines what is relevant and what is not relevant. Discovery must not be oppressive. So if a certain class of documents that is being asked to be disclosed, there's just too much of them, or maybe spanning too many years. Okay, that might be cost too much time and money to provide discovery. There might be an argument to limit them. Fishing is not allowed. So fishing basically means I don't know whether they are relevant documents, but I'm fishing for documents. Okay, so I'm asking you to disclose this, and this, and this. Okay, in the hope that I may find something that helps me. That would be fishing. Thirdly, possession, custody, or power. They are separate requirements. So notice the word or. Possession means something I currently hold physically and have the right to hold it. So it's mine. Custody means something I hold, but I may not have the right to hold. Power, meaning there is a personally enforceable right for me to obtain this document without consent from anyone. Okay, so let's say there's some other party who are holding documents on my behalf. I have the power to obtain it, even though they're not in my possession or custody. Let's say it's in my warehouse. There are different grounds to object to production. So notice though, disclosure of existence is I'm telling you these documents exist. Production is actually giving them or showing them to the other party. The common grounds of objection, we have legal professional privilege or simply privilege. There could be without prejudice communication, less often used, privilege against self-incrimination, and public interest immunity. So very quickly, what is LPP? It is a basis upon which a party could be exempted from producing documents. So there are two types. There is legal advice privilege and litigation privilege. LAP applies to confidential communication between a client and legal advisor in his professional capacity for the dominant purpose of giving legal advice. So first, it must be confidential. It could not be something, legal advice given in the public, let's say on a minibus. It is between the client and a lawyer, and this lawyer must be acting in his professional capacity. So again, not as a friend or someone on the street. For the dominant purpose, so the purpose of this communication must be to get legal advice. If it applies, then privilege attaches, and there is a right not to disclose it to the other side. Litigation privilege is similar, so communication between client and a third party. So this is not limited to a lawyer, but anyone. Let's say I'm interviewing witnesses about a potential claim, or I'm defending against a claim for the dominant purpose of pending or contemplated litigation. So either there's existing litigation, I know I'm being sued, so I want to get witnesses to help me defend that. So that document or that communication might be protected by litigation privilege. Or maybe there is contemplated litigation, which is there is a reasonable prospect that I know I'm about to be sued by someone because I've been threatened with legal action. So that would also apply. Important, though, to look at the reason for the production at the time of its production. So let's say a document was prepared. We look at the time when the document was prepared. Was there litigation back then? So the mere fact that a document becomes relevant in litigation afterwards, okay, does not make them privileged. A privileged document, an unprivileged document, will not become privileged by simply handing them to a lawyer to help with litigation. So we look at the time of creation of this document or the communication. No privilege attaches where the communication is to help crime, fraud, abuse of statutory powers, defeating or frustrating the administration of justice. So we call this the fraud exception to privilege. If you are seeking legal advice to help you facilitate a fraud or a crime, there would be no privilege. Privilege could attach to only part of the document. So it is not the case that just because one part of the document is privileged, the entire document must be privileged. Okay. Sometimes you're allowed to blank out or cover up the privileged part, but the other parts must also be disclosed. Merely being confidential does not make it privileged. Okay, so merely being confidential is not a ground for objection to production. Some more principles about privilege. Once privilege, it is absolute. Absolute meaning it is not subject to balancing against other interests. Once privilege, then there's no need to disclose it, no need to show to anyone, subject to it being overridden by statute or court. This is very limited. Sometimes the client may choose to waive privilege. So also know that privilege is owned by the client, not the lawyer. So only the client has the right to waive privilege. Examples here are intentional waiver. So I deliberately disclose it to the other side. Or unintentional. Let's say I did some act that had the effect of waiver. For example, in my evidence or in my witness statement or in my affidavit, I quote legal advice that I receive. So I unintentionally give up my privilege. Implied waiver is by conduct I'm deemed to have waived privilege. So let's say I'm suing my former solicitors for negligence. Of course, impliedly, my former solicitors have or can disclose and rely on the legal advice given to me previously. Okay, because it's absolute, it means it cannot be overridden by some supposedly greater public interest. Okay, just briefly about the other grounds of objection. Without prejudice communication are communication in the context of negotiation for settlement. Those are protected by privilege. We will come to this again in the settlement topic. Privilege against self-incrimination. So if I have to produce this document and the contents may subject me, may expose me or my spouse to criminal proceedings, then I can claim this privilege under evidence ordinance, or the government can claim PII against documents for public interest grounds. So, for example, internal police documents. So these they would not want to show anyone. Process of discovery. So what actually happens in discovery? There are two basic steps. The first step is listing documents. So both parties would prepare something called a list of documents. It should contain all documents that satisfies these three requirements, okay, that we discuss. But there's nothing attached to it. So it is just a list of documents. The purpose is to disclose the existence of documents, but not showing the other side what the actual documents are. Second step, production. So after I serve my list of docs, the other side has the choice to ask for inspection. So they can either come to the law firm and look at the originals, or they can simply ask for copies of everything, okay, subject to paying costs of photocopying. Okay, so some more detail about the list of documents. There is a prescribed form in Form 26 in Appendix A of the RHC. It is only a list of documents, so it does not contain documents. The party preparing it must make sure it is in a convenient order. There must be adequate description of each document to enable it to be identified. So the structure of the list of docs are, there's a preamble that states the nature of the documents in Schedule 1 and 2. Confirm that there's no other documents other than these. Schedule 1 Part 1, this is the only important part of the list of docs, because you can see here, every other part are standard form, so they usually do not change. The part that's important is Schedule 1 Part 1. This is the example here, is you can see there's a list of the documents, a description of it, and the date of the document. Okay, so this is what is in the party's possession, custody, or power list with a brief description. Schedule 1 Part 2 is something you do object to production, so you only briefly name them. So as I said, usually it is in a standard form. So you would broadly state documents which are legal advice where privilege is asserted. Okay, so only general descriptions. Schedule 2 is what you no longer have, but you used to have them. Okay, and state what happened to them. And then at the back of the list of docs, there is a notice to inspect. Again, this is usual standard form. You state the time and place within 7 days when inspection can take place. So usually at the solicitor's office. In practice, as I said, usually there's no actual inspection of the original unless there's a dispute on the authenticity of documents. Usually, one would only ask for copies, and that will be enough. Okay, and they must be provided within 7 days. And court may order supply if parties fail to supply the copies. Deemed admission. General rule in Order 27 is anything listed in the list of docs, the other party is deemed to admit that they are true, so they're authentic, if, okay, according to their description. If a document is described as original, then they're deemed to be original. If it is described as a copy, then they're deemed to be a copy. Therefore, if you are the receiving party, you want to dispute certain document being a forgery, it is fake, then you must do something. You must actively challenge authenticity. Okay, so either it has already been denied in the pleading. So in the earlier stage in the pleading, I already said your will is forged, so then there's no deemed admission. Or you can also serve a notice within 21 days of inspection and say, I do not admit authenticity, you prove it. You hire your handwriting expert and prove it is authentic at trial. Finally, what is referred to as the implied undertaking, basically it means a receiving party of discovery has an implied undertaking, so a promise, to only use those documents for the purpose of litigation. So not to use it for any collateral purpose, unless there is leave of the court or consent of the other party. So the rationale is to encourage both parties to give full and proper discovery and to balance the already very serious invasion of privacy. So what are examples of collateral purpose? Uh, okay, the use is not reasonably necessary for the proper conduct of litigation of the action. So, example, using sensitive commercial information obtained in my business activity. So rather than litigation, I'm also using it to in my other business and maybe giving it to my friends, using materials in a different action, using materials in the same action in respect of a counterclaim that is unrelated to P's claim. Okay, and there are certain exceptions to this implied undertaking. First, documents produced under Order 24, Rule 10. We will come to this in a later video. Materials obtained pursuant to a Norwich Pharmacal Order. Again, we'll come to this in topic 11. Documents that have been read to the court or referred to in open court. So now they cease to be confidential. They are now in a public domain or deemed to be in public domain, unless court orders otherwise. And generally, the court can relax the undertaking in appropriate circumstances.